The daughters of SueNeillFraser arriving at Risdon Prison. This morning isn't one of their regular visits. There's activity behind the fences as Neill Fraser is handed over, leaving prison at long last, but not in the way she wanted. After 13 years behind bars, Susan Neill Fraser was driven out of prison. Found guilty in 2010 for the murder of her partner Bob Chappell, Neill Fraser has always maintained her innocence. In the years since, there have been court appeals, vigils and protests against her conviction. She's now found a kind of freedom, but it's as a guilty woman who's subject to a parole period that will last a decade.
We're so excited to have Mum out from prison after all these years, but I suppose this isn't the outcome we'd hoped for.
Upon leaving prison, Neill Fraser and her daughters headed straight to Highfield House to meet with her parole officer. While she may intend to maintain her silence, a possible requirement of her parole, her daughters say the fight to prove her innocence is far from over.
This has renewed our energy, having Mum out, to clear her name.
Neill Fraser didn't have to admit guilt or show remorse to be granted parole.
In December of 2008, Sue Neill Fraser and Bob Chappell had purchased their dream yacht in Queensland and with the assistance of a relocation crew sailed it down to Hobart where they lived. The yacht was going to be their retirement plan. It was early morning on January 27, 2009 when the yacht, Four Winds, was discovered sinking at its mooring. Hobart police were contacted and 2 police officers attended the scene, where they were transported out to the yacht by a local rowing coach. Soon the yacht was crowded, with police and salvage crew who were working to prevent it from completely sinking, and a phone call was made to the residents of the owners of the yacht to inform them of the situation. The phone call was taken by Sue Neill Fraser, who informed them that her partner Bob Chappell should have been on board the yacht. After the call, she immediately drove down to Murrayville Esplanade to find out what was going on. On board the yacht, there was no sign of Bob, and disturbingly, there were a number of things that could only point towards foul play. Below deck, there were blood splatters. Also, a small hose had been cleanly severed with a knife. The seacock opened, and the bilge pumps and alarm disabled. The yacht's dinghy was found resting on rocks by the shore, its rope having been placed inside it. Had the rope come loose from wherever it was previously tied, it should have been trailing in the water.
Just after 7 this morning, police found the man's 16.5-metre sailing ketch, Four Winds, taking on water just off Maryville Esplanade in Sandy Bay.
Police remain baffled as to what's happened, but murder hasn't been ruled out.
On the same day, it was discovered that Bob was missing. Police conducted an informal interview with Sue, who was in a somewhat distressed and confused state. Media footage from that day shows an image of a woman hunched over and holding herself in a way that can only be interpreted as shock and distress. Yet police still felt it necessary to interview her. Sue was confused and could not remember many of the things which were asked of her. This interview was later used against her as evidence that she had lied to police. On the following day, police once again questioned Sue at her house. As far as Sue's state of mind at the time, and therefore her capacity to answer questions with any degree of accuracy, her level of distress was such that her daughter had contacted her GP and organised a script for Valium for Sue. At the time of the interview, therefore, Sue would not only have been in far too much distress to provide clear answers, but was also medicated with Valium and therefore would have struggled to remember details. This interview should never have been considered as evidence against her, and yet it was a constant sticking point for detectives who claimed it indicated deception and therefore guilt. Understandably, when Sue was re-interviewed in March and then later in May, She could not recall much of what had been discussed around the time of Bob's disappearance. When it came to the forensic side of the investigation, the Keystone cops could have done a far better job. By the time forensic scientists finally examined the boat, there had been countless police, detectives, salvage professionals and civilians all through the boat, with absolutely no attempt having been made to preserve the crime scene. Crucial evidence was lost or not tested. A jacket which had been found abandoned on the foreshore had been handled by multiple individuals, then left forgotten in the boot of a police car and finally dropped and left on the ground in a police garage for several days.
Then there's this red jacket left on a fence. There's a single dark hair attached to it. Sue, in shock and doped on Valium, tells police it's not hers. The prosecution alleges she's dumped it. A police officer throws the key piece of evidence in the boot of his car. Later, it spent 4 days on the ground in a police car park. But in court, police testified it had remained in their custody.
Most crucially, when it came to the dinghy from the yacht, the forensic scientist who performed tests, having found a minimal reaction to luminol spray on one section of the boat, subsequently resprayed over the top of the original spray. This practice is referred to as overspray. Luminol testing is a presumptive test. This means the spray will luminesce to show the presence of a range of reagents, including bleach and paint. Luminol will also react when there is overspray. In other words, if used incorrectly, it will react to itself.
Imagine you're a juror. You're told that Sue's dinghy was covered with Bob's blood. Pretty convincing, right? Fact is, there was no blood in the dinghy. The glowing blue is a reaction from the testing agent luminol, and Victoria Police Forensics supports that.
Despite the positive results from the luminol testing, there were no traces of blood discovered on the dinghy, and yet in trial, photos were used that showed the glowing luminol to convince a jury of the prosecution's hypothesis that Sue had used the dinghy during her efforts to dispose of Bob's body. Even the judge brought up the dinghy during instructions to the jury prior to them going in to deliberate on their verdict. It was August 2009 when Sue was arrested on suspicion of murdering her partner Bob. Police alleged that she had killed him below deck, then winched his body up 2 sets of stairs and through another area below deck, before subsequently dragging his body to the dinghy at the rear of the boat, lowering it into the dinghy, and then, having weighed his body down with a fire extinguisher, dumped it further out in the Derwent River. The problem with this hypothesis, of course, was that firstly, prosecution claimed that she had struck Bob over the head with a wrench, yet there was no evidence that this weapon had even existed. There had been no mention of one being missing, and one was never found. There was never any explanation given as to the basis for this story. Likewise, the notion that Bob had been weighed down with a fire extinguisher was also based on speculation. There had been an old decommissioned fire extinguisher on the boat when Sue and Bob purchased it, but Bob had immediately purchased new ones. A family member who had been on board the yacht prior to Bob's disappearance had, due to her own work background, made note of the position of fire extinguishers upon boarding the boat the first time, and stated that she had not observed the old fire extinguisher at the time. In the lead up to Bob's disappearance, Sue and Bob had been doing a lot of work on the boat, and Bob had disposed of several wheelbarrow loads of junk into a skip bin at the marina. Given that the fire extinguisher in question was no longer in use, it seems highly likely Bob had already disposed of it prior to the night of his disappearance. There was no proof that it had still been on the boat that night. A presumption was simply made after Sue, in a state of overwhelmed confusion at the time of being taken to inspect the boat to see what was out of place, questioned its absence. Tasmania is a small place, very different to other Australian states. This is particularly evident when you look at the behaviour of Tasmanian media. There are certain media outlets in Tasmania which prefer to follow the most scandalous narrative in cases, rather than examine both sides of the story. There is a relationship between prosecutors and Tasmanian media, where prosecutors will feed the media with information and even evidentiary photographs in order to promote their own case. reporters revel in these scurrilous tidbits and run with their story, pushing the preferred narrative. Far too many Tasmanians simply accept events as given to them by local media and draw conclusions accordingly. In Sue's case, this very definitely occurred. Before Sue's trial had even begun, she had been placed under the intense scrutiny of a trial by media, and subsequently, in the court of public opinion, had been found guilty. To believe that in such a small state a jury would have been unaffected by the media coverage seems to be extremely naive.
When Mum sort of challenged them about the boat not being searched properly, this is the police, they came out and said to the media that if anything were to have been found on the boat, that it would have been put there after that, because they'd thoroughly searched it. So we're sort of sitting there going, well, we know we know it's not accurate. Mum knows it's not accurate.
Then, of course, there was the exculpatory evidence, a source of DNA the size of a dinner plate that at the time of the trial belonged to an unknown individual. Cloths which would have certainly yielded DNA evidence, but were not tested and subsequently lost. The known violent criminal whose yacht was moored in close proximity to the Four Winds. The witness sightings of an aluminium dinghy as opposed to Sue and Bob's inflatable. And, most importantly, the sheer physical strength that would have been required to transfer the dead weight of a deceased person up from below deck onto the dinghy and to then dump it in deep water without capsizing the dinghy in the process. A retired police detective from Victoria organised a reenactment of this, and it was extremely evident that even for two strong men the task was very difficult. Had Tasmanian detectives made an attempt at a reenactment, they would have seen immediately that Sue was, without a doubt, not their person. There were no witnesses who could place Sue at the scene of the alleged crime, no body and no weapon. The one witness brought forward by prosecution was a known criminal who had approached police the day after Bob's disappearance and offered to make a statement in return for leniency with his most recent charges. This witness claimed that Sue had approached him years earlier and asked him to deal with Bob in a manner similar to that described by the prosecution. With his extensive criminal history, and particularly given that he appeared to be coming forward for entirely self-serving reasons, this witness should never have been considered as credible, and under different circumstances would have been quickly dismissed by police. Not only that, but had police done a thorough investigation and looked into the many questionable individuals who had been at Murrayville Esplanade on the night of the disappearance, they may have realised that one individual who had been there that night, along with his 15-year-old girlfriend, was known for stealing off yachts and belonged to a family well known to law enforcement, and also had ties to the family of their star witness.
There's no body, there's no murder weapon, there are no injuries to be interpreted, and yet the prosecutor put all those things together and told the jury that this man had been struck on the head and killed with a single blow.
Dr. Bob Moles is Australia's leading expert on miscarriages of justice. Of the hundreds of cases he's reviewed, Bob ranks Susan's among the worst injustices in Australian criminal history.
In August 2010, Sue was convicted of Bob's murder and sentenced to 26 years, with a non-parole period of 18 years. This sentence was later reduced on appeal to 23 years with a non-parole period of 13.
We were absolutely naive as a family to the criminal justice system altogether. We had never had any experience with the police, the media, the legal system, and we took it for granted that Mum could never be convicted because the evidence was so shoddy.
I was sure I'd be acquitted. I couldn't conceive that the injustice would stretch to conviction.
I just say that we're extremely disappointed with the outcome tonight. This is not how we expected to go at all, and this is certainly not the last you'll see of us here. We're just going to keep fighting until we see Mum acquitted.
Over the years, there have been appeals made on Sue's sentence. The person whose DNA has been found on the boat has been identified and not only admitted to being present on the night of Bob's murder, but also named the individuals who were responsible. and yet Sue has never been acquitted. In Tasmania, it is a normal requirement for a person who is eligible for parole to first admit to having carried out the crime for which they were incarcerated, and also to demonstrate remorse for their actions. For SueNeillFraser, as an innocent person, these were requirements that she could not fulfil. In Sue's case, however, the parole board allowed her to be granted parole without first admitting guilt and subsequent remorse. There are restrictions placed on Sue through the terms of her parole agreement, and the media continues to hound her and her family paparazzi style. The fight now continues to have SueNeillFraser exonerated for a crime that she should never have been convicted of.